Hello everyone, Derek Johnson with Tatango.com. I'm here with Joe Bowser from Innovista Law, home of the TCPA Defense Force, and we're trying something new. We're trying to do a TCPA case review today, where we're going to actually discuss what is happening in the court systems with TCPA cases. So, hey Joe, how you doing?
Doing well, Derek. How are you?
Good, man, good. I know we've done a few videos together, so it's always good to see you.
Likewise.
Okay, so the first case we're going to review today, and you can find many other cases on our YouTube channel, is a TCPA text messaging case, which was Ricky R. Franklin versus Express Text. And Express Text is a SMS software provider, correct?
Correct. That's
okay,
right.
Perfect. So I'm going to review kind of some of the basics, and then I'm pretty sure you have even more information, and then we can discuss how this case impacts text message marketers. So what I have written down here and kind of what I've summarized from this case is there's this person named Ricky Franklin, and he received 115 text messages between July 2015 and September 2016. So about a year or so, he's been receiving a lot of text messages. It looks like Express Text was the SMS software provider, but the client of Express Text, the people sending the text messages, was WorldWin Events, and so they hired Express Text to be their software provider. So in September 2016, Franklin, so the consumer, responded help to one of those messages and received a response directing him to call Express Text to opt out of the messages. So giving him, when you text help to a short code and then it responds back, like, hey, if you need help. So instead
that's what he did.
Okay, so he texted help. Now, it didn't come back with a WorldWin message. It came back with a Express Text message saying, please contact Express Text to opt out, right?
That's what happened, right?
Okay.
And he did make that call.
Okay, so yeah, I have that here. Express Text employee received the call and confirmed that this person, this consumer, Ricky Franklin, had been removed from the company's database. Now, do we know that that actually happened?
That seems to be undisputed.
Okay.
What happened after that is he began then having a conversation with the platform where he would text things like, hi, and is this a real person behind these answering these text messages?
Okay.
So he continued the conversation after he was opted out.
Okay. So he opted out through, most likely through he was called into Express Text and said, hey, opt me out. They opted him out. And then for some reason, he started texting into the short code again, saying hi, and is this a real person answering these text messages? And that's so explain to me where the violation of the TCPA kind of fell, or why he thought, there was a violation.
He thought all of the message he received were in violation of the act. So he didn't care whether it was the ones where he claims he had no idea why he got them, and then the ones after he opted out. For him, all of them were unsolicited messages that violated the act and entitled him to damages.
Okay, so this is the 115 text messages. This is not him texting in and saying, hello, or is this a real person answering this text? And then he would get one back, like a response. He was saying the 115 were, a TCPA violation, or all of them, just every single one?
Every single message.
Okay. Now, so what was what was the result of this? Did WorldWin and Express, I guess he was suing the text message provider, not WorldWin, right?
Right. He only sued Express Text.
Okay. And why would a consumer do that instead of suing WorldWin Events?
Well, so he was there pro se, which is to say without an attorney. So there may have been any number of factors that led him to only sue Express Text. He might think that WorldWin doesn't have the money to back up any settlement or judgment he might get. It might be hard to get WorldWin into that same court, such that he'd have to have two different lawsuits about the same text.
Okay.
So if you think Express Text can foot the bill, as it were, you don't add necessarily the company who actually sent the messages. He may have had a hard time finding out how to even serve them with process, with the complaint and the summons.
Okay,
so
interesting.
Getting a lawsuit off the ground does have some complicating factors, and he might not have been able to thread the needle to get both Express Text and WorldWin in the same case, in the same court.
Okay, because usually, at least from my experience in watching these court cases, is usually the consumer is suing the brand, because usually the brand, let's say, in one of our other TCPA reviews, we're going to be reviewing Kohl's.
Right.
Kohl's, I would assume, has more assets than a software provider like Express Text. So
I would expect.
It's usually brand, but in this one, it seems like WorldWin might have been a smaller company, and Express Text, is easier to get a hold of. So they went after, we presume, the company that he thought had the most, exposure.
Right, and WorldWin might have been a lead generator that's hard to pin down. So you don't know what the circumstances were that led him to choose Express Text. I have litigated against Ricky Franklin before.
Okay.
He's reasonably aggressive, so that's why I'm assuming he had a hard time putting those two in the same case.
Okay, so is this Ricky Franklin person, is he an attorney, or is he just representing himself as a non-attorney?
He represents himself as a non-attorney.
Oh, okay. I didn't know you could do that.
Yeah, sure.
Okay.
I mean, the courts are open to everyone, and he's free to represent himself pro se. This is probably his 10th TCPA case. Okay. So he is very familiar with the TCPA. He has a number of phones, and he keeps good track of who calls and who texts him. And so it comes as no surprise to me personally that he filed this case.
Okay. So this whole case comes down to he's sued under the TCPA, and the TCPA, if you win, could be between $500 and $1,500 per text message that is received, right?
Correct. Well, actually, you don't even have to receive them. So you get the liability attaches to the initiation. So there are cases that show that calls that you didn't receive are still violative of the act, because the misdeed essentially is to attempt the call, to initiate the call.
If it's if a spam blocker blocks the spam, you still, even though you didn't get the message, you still actually could, have a judgment against the person that sent the spam.
Right. There's not a ton of case law on it, but
interesting.
Yeah, it's an open debate.
So he was going, let's say, in this case, it says 115 text messages. So it'd be 115 times anywhere from $500 to $1,500.
Right.
Okay. So that's a lot of money just for him. And then he might even want to create what is called a class action lawsuit. So he'd bring other people that feel they've been wronged. And then, so this could have been an extremely big case.
It could have been. Now, what you can do is sue for your own injuries. What you can't do as a non-attorney is bring a putative class action, because there you need competent class counsel. Okay. And so since he doesn't have a JD, he couldn't do that. Now, that's not to say that the other plaintiffs' attorneys who watched TCPA cases closely weren't thinking, what do we have here? Let me jump in and pip Ricky to the class action case.
Okay, so somebody helps him out, essentially, once there's some meat on the bone, I guess.
Or the TCPA plaintiff's attorney would just push Ricky out and kind of take over and say, I'm representing the class, and Ricky is just a class member. So you could get blood in the water. Because you don't need his permission,
essentially, because you can find your other people.
Oh, yeah. There are plenty of TCPA cases where, it's plaintiff 1, and then a couple weeks later, or a couple days later, plaintiff 2, and then the plaintiff's attorneys fight over who's the right lead counsel. Okay. So you get that blood in the water, and sometimes you can get a little fight from the sharks.
So what happened in this case?
At the trial level, the Express Text, the defendant, very quickly moved for summary judgment. Okay. And summary judgment is the procedural vehicle where you go to the court and you say, look, all of the undisputed material facts show that we win as a matter of law. So let's break that down a little bit. Undisputed, meaning neither side has a real beef about what actually happened. Okay. And then material facts mean the fact has to matter to the outcome. So if it was cloudy on the day he got the text, that's not material to a TCPA case, but the weather might matter to a traffic accident where it depended whether it was reasonable for you to slow down when it was raining or whatever. So the weather's not material in some cases and material in others. So you got to show that everybody agrees on what the key facts facts are, and the judge decides what's key. And then if everybody's in agreement about what the undisputed facts are, does one side win or lose as a matter of law? Which is to say, there's nothing left for the jury to do, so we don't need a trial because the judge decides the law and the jury decides the facts. But if there are no facts up in the air, I don't need a jury. So judge, here are the facts. You just figure it out.
So this is pre-jury, Law and Order type, what people usually kind of see two sides arguing. This is, hey, the facts are the facts, so there should automatically be a ruling. We don't need all the other stuff.
Exactly.
Okay.
And so, but for everybody watching the video, filing a summary judgment motion a month after answering the complaint is very early. Typically, discovery takes anywhere from 4 to 5 months on the very aggressive end to years.
Okay.
On the reasonable to far end. So when Express Text moved for summary judgment early in the case, it was an aggressive move to try to just put this case out of its misery early.
He wanted to win it, right? Oh no, Express Text was the one that filed this summary judgment, right? Or they required.
Correct.
Okay, so they thought this was so ridiculous and that it had no merit, essentially, that they said to the court, let's just decide it right now, based on all the facts. And they were confident enough that all the facts were leaning towards them, I guess.
Correct. Right. So they put in a C-level affidavit explaining how the Express Text platform works and how it would have been its customer who chose who to send the messages to, when to send the messages, what the content was going to be, a typical platform versus sender setup. And so since they were the platform, they explained to the judge, Your Honor, we don't do the kinds of things that the TCPA attaches to sender liability, right? We just provide the underlying technology that a sender uses, just like you and I might use to make a phone call, right?
Okay.
It doesn't look like an iPhone, but from someone who wants to send commercial text messages, this is how the platform works, but it still requires a high level of involvement of the user to decide who gets the messages, what they say, when they're sent, and so on and so forth. And that, under the law, is the sender. And in response, Mr. Franklin said, well, I don't know anything about your Express Text relationship with WorldWin. I don't know how your platform works. I hear what you're saying, but I can't rebut any of this. And so there's a procedure in federal law that allows the plaintiff to say, hold on now, this summary judgment motion is being filed too early. You need to give me a chance to go depose these people, get the underlying documents, and engage in the kind of discovery that I'd need to test those propositions that you're putting into evidence. And the trial court was having none of it. They said that the facts are undisputed, which is unsurprising because Mr. Franklin didn't really have a chance to test them, and gave summary judgment to Express Text. And Mr. Franklin appealed to the Seventh Circuit Court of Appeals, which is the appeals court that covers that Chicago Federal District Court. And just by way of background, the Chicago Federal District Court has one of the highest TCPA caseloads in the country. So they see these every day. They get filed there every day. It is clogging their dockets. And you can sense from some of the judges, at least, a level of exasperation at these kinds of cases. Some of them have merit, but plenty of them don't. And so when these combination of professional plaintiffs with, not a clear path to victory come forward, it's not surprising to see a trial judge say, okay, I've got a lot of these. Let's get the wheat separated from the chaff and get rid of the bad ones.
Okay.
And so I'm sensitive to the trial court's ruling in this one, but Mr. Franklin appealed to the Seventh Circuit, and they briefed the issues about the extent to which Mr. Franklin should have been given more discovery on the one hand, and whether he should get discovery on all of those messages that came after Express Text manually opted him out of the campaign.
Okay.
And so that's the decision that came out earlier this month in March of 2018.
And what was that? Was it that he doesn't have that right?
The Seventh Circuit reversed and said that he did have that right, that the trial court granted summary judgment to express text too soon, that it was unfair essentially to the plaintiff to not be given a chance to get the contract between express text and WorldWin, to figure out how the platform really works in practice and kind of get under the hood and test the representations that were before the court in the form of that affidavit that supported the summary judgment motion.
Okay.
So they said that the trial court, the trial court jumped the gun, and Mr. Franklin should get that discovery. And then, of course, express text, assuming everything they said is true, they'll just refile the same motion and say, even after discovery, Mr. Franklin's unearthed no information that would suggest that we are the sender of the messages.
Okay.
So I would imagine that this is a road bump rather than a real change in the outcome of the case. So, assuming, of course, that express text was honest in the declaration and nothing new comes out. The important thing for us, for the bystanders of this case, and the folks just that track TCPA developments in the courts, is what the Seventh Circuit concluded about his messages that follow the manual opt-out. They called foul on Mr. Franklin's attempt to gin up more messages by texting hi and, what's the weather? Is there a real person behind these answers? The Seventh Circuit was unequivocal that he gave express consent to get answers or automated messages when he knowingly sent textual narrative text to a platform that he knew to be associated with an auto-dialing type platform where he did anything but text stop.
Okay.
Right? Like Express Text and the brand did what it was supposed to do. They told people, if you want to stop getting these messages, text stop. 4 letters like a stop sign.
Yeah.
It's easy. Everyone can do it. Just do that. Don't play games and try to, go left, go right, shuck and jive.
So it seems like the TCPA is being a little more kind of, I guess, brand and software friendly nowadays, or they're starting to see a lot of these types of cases where they're manufactured cases and it's not holding as much weight as it used to maybe when it was more, TCPA was newer to people.
Well, unfortunately, there have been bad partial revocations in phone call cases.
Okay.
But on the SMS space, I'm seeing courts take a much harder line for opt-outs and revocations.
Okay.
Where I agree with you in that sentiment. So I wouldn't put it TCPA writ large.
Just for SMS.
For SMS, because you have the text, like you see what everybody said, right? It's recorded. Everybody's got a log of what happened. So the courts have a very clear understanding of who said what to who, and they see that narrative go back and forth, and it's much easier to call balls and strikes there and say, look, you have a very easy opt-out mechanism. The fact that you chose to avoid it means that you were not trying to exercise reasonable opt-out methods, and we're really just trying to gin up your TCPA damages.
And so you have the record, of the text message. And now you said that was kind of just, basic. It is something to look for in a software provider to make sure the records are kept. I've heard some kind of crazy stories where, after a year, the records are destroyed. It is a good example of why keeping records, even hypothetically, let's say you leave an SMS platform, go to another platform, you need to get all the records from the original platform, of all the messages in and out before you leave the platform.
Right. Because consent is an affirmative defense, so it's on the burden of the sender or whomever's making those calls or texts to prove consent. So you can't just put in a declaration that says, oh, well, don't worry, court, we really did have their consent to send those messages. Because then you're definitely going to, not definitely, but in all likelihood, you're going to trial on that issue. And that's not where you want to be. You want to show that the undisputed evidence shows that you had consent. And the TCPA has a 4-year statute of limitations. So that's the minimum that you want to keep that kind of consent record for. We've definitely heard folks say, well, I don't want to keep my call records because that's going to show how many people I called or sent text to. Well, bundled in those call records is the consent typically. Yeah. So you don't want to throw the baby out with the bathwater. So if you're conducting your campaigns properly, you have every incentive to just keep the data that you have and show consent. And it also helps, in a related vein, make it more difficult for the plaintiffs to get class certification. Because if you can show that consent is a key issue that separates potential class members, you create these individualized mini trials, and the courts aren't going to grant class certification when they see that consent is an overriding issue in the case. Okay. So the more evidence of consent that you have, the better for your defense strategy. Because losing class certification is a key inflection point in any TCPA case, because then the plaintiff's lawyers are, rubbing their fingers together.
Yeah, they see some
the yacht. Yeah. And
okay.
They're just off the settlement.
And just to be clear, so the 115 text messages, this Ricky Franklin thought they were, let's just call them unsolicited. He didn't opt in for these text messages. Right. Maybe in that, I don't even know if it was decided or not. So
it was.
Oh, it was. Okay. So
and it was not.
Oh, it was not. Okay. So let's hypothetically say that, 115 text messages, these were unwanted, because I think what it brings up is a more interesting point is Express Text got themselves out of the lawsuit. Now, if these were solicited, unsolicited, whatever, it really doesn't matter, because Express Text, what they were telling the court was, we don't belong in this lawsuit, in this TCPA lawsuit, because we are not the sender.
Right.
Okay.
Yeah, that's the key verb, right? You have to initiate or make or send the message. Now, vicarious liability can stretch out who is the sender, but the case law is pretty clear that if you don't control the questions of whether to send the message, when to send the message, who gets the message, and courts and even the FCC waffle a little bit about the role someone can have in crafting the content of the message. But if you're not answering the whether, the when, and the to whom questions, you're in almost all cases not the sender of the message.
Okay.
And so that's what the TCPA really covers is I am putting liability where it should be, which is who chose to send that message.
And in this case, or most cases, when you're using a software provider, if you're a brand like Kohl's or WorldWin, CarPros, whatever it is, it's usually, the brand is going into the software provider, they're logging in, they're selecting which, subscribers or people that didn't subscribe, whatever it is, hopefully not, to message, they're creating the message, they're clicking send, and the software provider essentially just sits there being a software provider.
Right. The analogy is if I start spamming people via email, you don't sue Microsoft just because I'm using Outlook.
Yes.
Right.
Okay.
Like I chose who to send the messages to.
Yeah.
It's on me.
Okay.
So that analogy is good so far as it goes. And carriers and fax broadcasters have explicit FCC exemptions, such that if they exercise no active control in the recipient list or the content of the message, they're exempt under FCC rules from liability.
And that's why you don't see, instead of Ricky R. Franklin versus AT&T, if the message came through AT&T to his phone, because they're a common carrier.
Yeah, that's not they are a common carrier, but that's not the basis for their liability.
Because they're not sending the message, just like Express Text is not clicking send.
Right. And so early after the passage of the TCPA, the carriers got together and said, this is not on us.
Okay.
We're a dumb pipe. You don't even drag us into these cases. And so the FCC early in the TCPA's life created this explicit exemption for carriers because they didn't want to get drug into lawsuits. Now, back in the 90s, after the TCPA was passed, there was just a small smattering of lawsuits. It's nothing like the 4,000 to 5,000 cases a year volume of cases that we see today. But in any event, the carriers got an explicit FCC exemption that contains those caveats. Like if AT&T and Verizon are collecting for their own bills that are unpaid,
and they're clicking send,
then sure, they're the sender, right?
Okay.
But if you're acting as the proverbial dumb pipe, they're off the hook.
And that's what software providers right now, if they are brought into these lawsuits, they are essentially saying that we are a dumb pipe, and that this is not, our problem, essentially.
Right. And a number of platform providers, SMS platform providers, went to the FCC and said, hey, FCC, you've given common carriers an exemption. Later, you gave so-called fax broadcasters the same exemption where, same deal. If you're not choosing who gets the fax, what the fax says, when it goes out, et cetera, you're off the hook. You're just the broadcaster and you're not liable. The FCC granted that one. So everybody thought that, we'll just continue that pattern and the SMS industry would get that same exemption. For whatever reason, the FCC chose to do a kind of totality of the circumstances test and rejected that petition to get that same exemption for SMS broadcasters and left it to the courts to look at that totality of the circumstances. But the courts have essentially crafted the same test. You just have to go through it time after time to show that you really didn't, for that client, engage in those things that would tip you over from broadcaster or sender, if you will, platform provider, over into essentially functioning like the marketing arm of that brand.
Okay, so this brings up, I think, two good points for text message marketers, just from my mind. One is, let's say, like a marketing agency. So let's say a marketing agency, we'll just use Express Text in this example, is using Express Text. It's hard to say. And let's say they represent, WorldWin Events. If the marketing agency is using the software provider, but they're crafting the messages, they're coming up with the time to send it, but the brand is the one, that is in the message, but the agency is the one doing all the work, that might be a liability for the agency. They need to be just as cautious as the brand or WorldWin.
Absolutely. Right.
Okay.
So if you're stepping in the shoes and essentially acting for the benefit of the brand who's hiring you to serve in that marketing campaign development capacity, there can be exposure there under what lawyers call vicarious liability.
Okay.
The most lay example you can think of is when the UPS truck driver hits you, you can sue both the truck driver and UPS because the truck driver was obviously working for UPS at the time and they were acting as their agent and UPS was the principal. And under centuries-old common law, you can hold the so-called principal UPS liable for the acts of the agent, the driver. Everybody. So in this case, the marketing agency is like the driver and the brand is the UPS.
So for like a marketing agency, number one, when they're doing text message marketing for a client, they need to be educated, on TCPA compliance. They need to be compliant. I always recommend going to a third party, counsel to, get that kind of advice. And then on the other side is the brand. When they're hiring a marketing agency, they should be checking the marketing agency to make sure they know, TCPA compliance because, they could get them in trouble as well.
Right, because what happens there, whenever you have a dispute between the brand on the one hand and the agency on the other, that's a side fight between the two of them. The brand always says, oh, the agency agreed to defend and indemnify me, and that's only as good as their resources to put behind the fight. These TCPA cases can get expensive fast. So if the agency is a small shop and they don't have the insurance to back it up or the financial resources, if there's no insurance available, to defend and indemnify the brand, you're still on the hook because the plaintiff doesn't care what the side agreement was between you about who's going to absorb any risks and liabilities associated with a campaign gone wrong.
Okay.
So both of those companies is most likely going to be defendants in the case.
Okay. And then
I was
going to say the other component is if all of these software providers are great, we're a software provider. It seems like in these cases, the TCPA cases, they are essentially always or most of the time able to remove themselves from the case and essentially saying, not my problem, it's the brands or the agency, whoever's clicking send, it's their problem.
Right. So because
Yeah.
I do think that the courts have settled on that test of where the platform provider can stay in the safe zone and not wear the sender hat, and where you start to blur the lines when you start to get involved in the client's particular marketing campaigns. And so as long as the platform providers are acting as the dumb platform, as it were, the dumb pipe, and just providing that brand facing functionality to be able to manage and conduct their campaigns and provide the interop between the brand on the one hand and the wireless ecosystem on the other, you're fine.
And I guess my point to that is, always watch out who's giving you their opinions, because I hear a lot of brands and marketing agencies, they'll go, no, it's okay. My text message marketing software provider told me it's okay. Now, the problem I think with that is that's great if the software provider is also on the hook, and if they don't have kind of this exemption, essentially, that the courts have kind of said that they have. So it does bring up another point. If you're a brand or marketing agency, software providers can give you great advice, but I would also get a third party's advice, which is like a TCPA attorney like you are, because at the end of the day, the Express Text or whoever it is as a software provider, essentially they can remove themselves from the liability.
Right. And I mean, there's two things going on there. There's the moral hazard of the platform provider wanting to generate more business, right? It's understandable, but there's a bit of a conflict there. To the extent that their revenues are increased by their brands and their consumers sending more messages, well, maybe you don't feel terribly comfortable about taking their advice. And then there's the related issue of, do they really track the case law every day?
Yeah.
Right. They might hear these things anecdotally at a conference, or, their lawyer told them this 3 years ago. Well, as we know, just last week, the DC Circuit issued a monumental decision, or 2 weeks ago now, in the TCPA context. And you've got to stay up to speed on these things. And it's not just appellate level decisions. The case law varies, somewhat dramatically based on where in the country you are. So depending on, whether you have a national footprint or if you have a heavy consumer base in the Southeast, for example, where the 11th Circuit has some fairly TCPA plaintiff-friendly decisions as compared to other courts like the Second Circuit that's been much more business-friendly. You just want to be sensitive to these things. And I don't know that a platform provider has the time or wherewithal to be focused on these things on a regular basis.
Yep. No, they're a platform provider because they spend all their time building a platform, not tracking TCPA law. And I've talked to David, your partner, on this a lot. And these videos are not supposed to replace legal advice. I think they're more just to get people thinking about things and asking the right questions of their TCPA attorneys.
Absolutely. Yeah, no, I mean, we put a ton of free content on our website because it's not a substitute for, nuanced, up-to-date analysis and advice that we couldn't possibly give here in this kind of setting, because so often the facts are critical in deciding which way you go, and you want to talk to your client about what their risk tolerance is and where they're willing to go, and so yeah. Well, I mean, I do think it's a good reminder to make sure that you're complying with the CTA guidelines as it relates to including stopped as often as you need to in your campaigns, and making sure that you're selecting a platform provider like Tatango that takes those expectations seriously. Because, I don't know that the outcome would have been the same if Express Text wasn't including stop instructions in those messages. So, right, you want to make sure that your platform provider is at least sensitive to those issues, because the outcome could well have been different had the court didn't have the record in front of it to say, well, you were given clear instructions every time to text stop to opt out, and when you didn't, everyone's going to assume that you were purposefully evading a reasonable opt-out mechanism. Yeah. Right. Right. Right.
You just don't understand how to opt out. If you reply back, is this a real person answering these text messages, and then it sends back a message saying, thanks, we got your response, that's not really helpful to the consumer, and they're going to get frustrated. And as you get frustrated, that's when you go to an attorney, and maybe you become a plaintiff, not a professional one. So I think it's a good lesson for SMS providers and the brands. Make sure your software provider, no matter what you're texting in and how you're interacting with the system, there's always those instructions in there, because a frustrated consumer is just something no one wants to deal with.
Exactly. Right.
Perfect.
Professional plaintiff or not.
Yeah.
You want everyone to have a good experience, right? The professional plaintiff is never going to have a good experience unless they have a successful case. Yeah. we can't really guard against every one of those. But from a brand management perspective, you want to make sure that everybody's getting the level of detail and attention that you'd expect.
Awesome. And you guys have a ton of resources on your website. What's your website so people can go and download those resources?
Sure. It's tcpadefenseforce.com. tcpadefenseforce.com.
And it's a great website. A lot of resources. And the blog is amazing. You guys, we think we're kind of up to date. You guys are 10 times more up to date on the TCPA stuff. And every time something comes out, you're right on top of it. So highly suggest everybody signing up for the email alerts or RSS or whatever you got to do. Anyway, that's great. So this was a TCPA case review for Ricky R. Franklin versus Express Text. We have Joe Bowser, TCPA attorney, and Derek Johnson from Tatango. Thanks, everyone.
Thanks, Derek. I'll talk to you soon. Thanks, everybody.